Are you interested in buying a particular property or business, but need to know more about it before you can be certain that it's for you? At the same time, are you concerned that another buyer may come along before you know enough to commit to the purchase? Then entering into a contract containing a due diligence clause may offer a solution to your dilemma. I'm John Gallagher from Argon Law, and I'd like to make a few points about due diligence clauses. To exercise due diligence means to carry out investigations about an asset sufficient to enable you to make a better informed decision about whether to commit to the purchase. The beauty of an appropriately drafted due diligence clause in a contract is that it enables the buyer to secure the right to purchase the asset whilst it continues its investigations, and to withdraw from the contract if not ultimately satisfied with its findings. Not every seller will be prepared to agree to such an arrangement. However, if the price and other terms proposed are sufficiently attractive, it's not uncommon for due diligence clauses to be included in contracts for the sale of all kinds of assets. It is important that due diligence clauses are properly drafted. Some key considerations for these clauses are: what rights of access the buyer has to the asset and information about it, what obligations the seller has to provide information, and how long the buyer has before a final decision to proceed with the purchase must be made. So ask the seller, their broker or agent, whether they will consider a contract containing a due diligence clause, and speak to your lawyer to ensure that the clause is appropriately worded. If you have any queries about other aspects of contracts for the sale of real estate or businesses, I'd happily answer them. And if you found this video useful, then be sure to subscribe to our blog and have a look at our website.